Okay, so since the webinar is now streaming live on YouTube, I would like to again introduce ma'am. She's a faculty with Texas A&M University, and she would be discussing the topic significance of international IP law and its harmonization with national laws. And if anyone has any doubt, they can address the same in chat box. And if it's too long to type, then they can wait till the end of the session and we will be taking your doubts then. Losico welcomes you, ma'am, and the session is now yours to handle. Thank you.
So, good afternoon, everybody, or good morning or good evening, depending on where you are. I was asked to address the topic of internationalization of intellectual property. And I was asked also to give a few prompts to see which are the developments in this area. And so, just as a matter of introduction, I have been working on international intellectual property for many years at this point. I started to work in intellectual property immediately after the TRIPS agreement was adopted in the late 90s. The TRIPS agreement, you might remember, was adopted in 1994 and was initially adopted by quite a number of countries in the world, but there were several other countries that joined towards the end of the centuries, and so in many ways the decade between 1995 and the 2005 early 2000 was a major decade of trespass changing landscape, with a lot of developing countries joining the WTO. There's big question, is the World Intellectual Property Organization becoming relevant because now we have a WTO agreement with the TRIPS agreement plus a WTO dispute resolution system that was start to be timidly used back then, but then enter in full force and would use several times. And so there was a lot of changes. And because of the TRIPS agreement provisions, several countries, developed countries as well, had to change their national laws. And so we have seen a lot of interesting development throughout that decade. And we also saw a very interesting phenomenon. Intellectual property became mainstream in studying, mainstream in practicing, from a very niche topic. Faculties had a class of intellectual property. Often the civil law country had copyright or industrial property, and copyright was often addressed as part of civil law. Then, common law countries had perhaps patent and trademarks, but it was still a very niche topic, often just an elective. And suddenly towards the end of the 90s, we started to see intellectual property entering the school curricula. We started to see far more specialization in practice. Was the time when I graduated, and then I started practicing. I started to do my PhD. Then from a PhD in competition law and intellectual property became full-blown intellectual property PhD track. And so a lot of changes in the harmonization, multilateral, multinational harmonization of intellectual property. And this is the first point we discussed, with your colleague when we were planning this seminar is, how has the internationalization of intellectual property developed? The Paris Convention was adopted in 1883, and the Berne Convention was adopted in 1886. And for a long time, the world of international intellectual property was really, first of all, mostly a transatlantic, in many ways, ventures in which the European, not even the European Union, just, some of the European continent country and the North American country were finding ways to agree on issues related to the substantial law of intellectual property protection. And even in all those issues where there was no agreement, we know that the Berne Convention, the copyright, continued to be quite divisive issues until just the last decade of the previous century, because most of the common law countries joined the Berne Convention, in over a century after it was created in 1989, the United States and many of the common law countries. And so the beginning of the story of international intellectual property was one of attempting to harmonize substantive law provision. And then with the TRIPS agreement, we have a big boom in that. And we have, a lot of the gaps that were still in the international WIPO agreement being filled by TRIPS with definition, with clearer minimum standards, ceilings, and so on and so forth. And then we had, as I said, the decade 1995, 2005, more or less, of adaptation of a lot of countries joining and, many laws being implemented or revised. And then, the second big moment in many ways, and, we see the acceleration of these various phases. The first phases was very long. We had the adoption of the Paris Convention, the Berne Convention, some other convention that were, like the Lisbon Agreement, but it's still a very small club. And then the revision of these various conventions with the Paris Convention, primarily we should remember the Stockholm revision. The Stockholm revision of the WIPO agreements was, a very, very important one. And then, the timid adoption of the Madrid Protocol, the Madrid Agreement, and the Hague Agreement, the PCT, that started, in the second half of the 20th century in just to also start to have, the basis for the administrative harmonization, but were still, in their infancy at that time. And, after TRIPS takes on and there is much more substantial harmonization, we see two different developments in the international intellectual property world. One goes to actors. In 2001, as everybody knows, China joins the WTO. That was clearly a geopolitical moment that happened on a certain, also tragic historical moment in 2001, a month after the attacks, the terrorist attack on US soils in New York and in Washington, D.C. The world really gathered together, and there was the Doha round of the WTO, and that was clearly a moment of union of the world, something that we very much needed now. And then China joins the WTO. And that in many ways put a very major weight on the WTO. China was already, of course, a member of the WIPO agreements, but that moves in many ways the center from, this transatlantic, in many ways, agreement. TRIPS is very much an agreement between the United States and Europe with the cooperation of many other developing countries. But when you even look at the text of the TRIPS agreement, you see clearly the matrix, of European and, American law. And, with the changing actors, China, and then of course, the BRIC country, one being China, Brazil, Russia, and India. So the emerging new strong voices in the international intellectual property arena, not necessarily with the same interest. Europe and America agree on a high threshold of protection because they still are, but they certainly were at the time the big producers of intellectual property and the renter of intellectual property to the rest of the world in many ways. those who were making higher money with royalties and so on through assertion of right, licensing agreement, and so on. And so the change of relevant actor from that axis to of course India was an original member of WTO, but I would say again, the rise, of India, the rise of China, the rise of Brazil, Russia, do become, they change the dynamics. And at the same time, the emerging power of several regional agreements. The European Union in many ways paved the way to make the world understand that when you're small, you are not counted in the same way as when you are bigger. And we want to believe that every country has the same power and the same vote in international organization, but we clearly know that's not the case. And so small countries, smaller countries, less powerful GDPs or technology countries also realize that if they join in regional agreement, they can create regional markets that are more competitive. And the European Union was clearly a joint venture on one side to, in many ways, create a peaceful European continent. Europe, Germany, and France, with very much the support of the United States and the Marshall Plan, did realize that another war would just torn the continent apart, and which was not sustainable. In the previous century, that we had too many, European continent wars, and that had to stop. And so economic union is the best way to fight national wars, between neighbors. And at the same time, it's the most effective way to create internal markets. Big countries have the advantage of already per se internal market, while small countries don't have internal market. And so the European experiment proved to the world that you can remain sovereign by relinquishing a bit of sovereignty to create, a union. And that also has witnessed the flourishing of several quite interesting regional unions. None has at this point the same level of integration of the European Union, perhaps with the exception of OAPI, Organisation Africaine pour la Propriété Intellectuelle, the French-speaking countries in Africa. But today we see in the African continent, of course, again, OAPI and the English-speaking and, ARIPO, so that's the other African Union that also includes countries that are bilingual in it. We have seen the surge of ASEAN, the Association of Southeastern Nations, in Southeast Asia, that includes 10 countries, including Malaysia, Philippines, Indonesia, and so forth. Of course, the Mercosur and the unions in South America. All these actors, along with the big weight actors, again, the BRIC countries, and of course the European Union, the United States, change the landscape. So where I'm trying to get, with this is the first point was international harmonization of the substantive norms, and then the actors that were shaping these norms change. And so we start to see more vocal requests for exceptions or more pushback against some of some of the standards that wanted to be implemented in international IP negotiation. And what happened was, the beginning of this century and throughout now, some call it, the collapse of the multilateral system. But in reality, what's happening is, an adjustment of the multilateral system to a more diverse participation. And clearly, when you have more people in the room with different interests, the negotiation cannot go as fast or as smoothly as if you have less people in the room with more aligned interests. And so that has also created a bit of a surge in regional agreement. We had more, again, when we look at this, the chart of the WTO, the FTAs, the free trade agreement or the international trade agreement, they never went away throughout the moments of international harmonization even when that was at its peak. GATT, that then found its permanent house into the WTO, already saw, even throughout the life of GATT, many bilateral or plurilateral agreements. And these were really, when you look at the chart, continue to steadily increase or to stay flat, but continue. But what happened in the past, several, I would say 20 years or 15 years, is that these fora have become more relevant for nation states to interact with each other on all the intellectual property matters, not just on matters related to goods and services, so trade, international trade in goods and services. And the European Union has, for example, established several international trade agreements in the past, decades. The United States also had, to a large extent, the United States pioneered some of these IP heavy international agreements, starting with NAFTA, following with Korea, US, Singapore, US, Chile, US agreement. For a while, as we know, now the United States has not been as active in international trade negotiation in the past few years. We will certainly see a change in that with the new administration taking over. And we will certainly see higher degree of involvement of the United States in international trade, but the European Union has certainly established an agreement. The Asia region has established the TPP without the United States, but certainly with Canada and several South American countries, and Asia Pacific, New Zealand, and Australia. Then there's been the RCEP, even though India is not part of it, and so I don't know, to be honest, the real relevance. And in intellectual property, RCEP doesn't really have any relevance compared to the existing standard. And so, I would say the second big change in international IP has been, or the second movement has been, the rise of different actors. And that has created a lot of issues, challenges. I'm an optimist, so I see these as a way to bring more people in the room, and we need to adapt to each other, and we need to clearly see the new dynamics. The WTO, it's a bit of a moment of stall right now. We have seen crisis, we have seen pushback, we have seen that even the DSU is not properly working because right now there is no requirement. They require number of panel members. But I'm an optimist. Things will change, and life goes in waves. Everything goes in waves. But the most important thing is the bottom of the bad wave is always lower and lower as life develops and as things develop. And so even in the moment of challenges for multilateralism, we have not seen the big low that we saw in the previous wave, and so I'm optimistic that the system is proving solid enough to go through the natural phases of the system, and so the international regional agreement have been playing a relevant role in this second for this second development, but we still had topic focus agreement as well at the international level. Now, let's remember the Geneva Act of the Lisbon Agreement was very controversial, but was still adopted in a multilateral system at WIPO. We have had the Beijing Treaty on, performing rights adopted at WIPO. We had the Marrakesh Agreement that relates to people who are blind or otherwise visually impaired, for the specific exception and limitation of translation and adaptation of materials for this category of people, that was also adopted within the WIPO framework, and is proving a very successful agreement, in terms of ratification. And so on niche topic, on certain topics, we have had activity at the multilateral level, not just, at the FTA or regional agreement level throughout, the past, I would say 15, 20 years. And that brings me to the third big development that we have seen in the past, I would say in the past 20 years, that is, while the world's power and, big power, regional power, smaller country might have considerable friction in intellectual property substantive norm. Not lots of the norms have been harmonized, and now the discussion here, should we increase the standards, should we decrease the standards, so on and so forth. A lot of the discussion is pivoted to administrative intellectual property law and administrative international intellectual property law. We have seen, from a handful of countries joining the Patent Cooperation Treaty in the 70s, when the treaty was adopted, now almost all the countries in the world are members of the PCT. The international registration system for trademarks, the Madrid Protocol and the Madrid Agreement also have developed from being quite esoteric agreement in which few countries were member of, now also a very large majority of countries, and that's growing, on a monthly basis still, are member of the Madrid Protocol and Madrid Agreement for the facilitation of international registration. When I started to live in Asia, only 2 of the countries in ASEAN were member of the Madrid Protocol and Madrid Agreement, and now most countries in ASEAN are member of the international registration system for trademarks. The design registration, the geographical indication, so the adoption of the Geneva Act of the Lisbon Agreement as well. This is more substantial, but also as the registration part, and the Secretariat WIPO also administered the registry. And so the third, interestingly, very relevant development in international IP has been the rise or the shift of attention to the harmonization of administrative procedure. So first creating international registration system that are still respecting national sovereignty, but also accelerate national registration through a centralized system. And then agreements on administrative standards. So in the trademark space, we have had the Trademark Law Treaty, the Singapore Treaty on Trademarks. In the patent space, we had the Patent Law Treaty. And we are looking at negotiation for a design law treaty that had some holdbacks for a variety of reasons, but there is a chance that that treaty goes through. And so this treaty have a bit of substantive norm, but for the large part, this provision are administrative. Now, those who oppose some of these treaties also say that harmonization of administrative provision increases always the threshold of protection, which in part is true, because institutionalize administratively even more intellectual property and facilitate registration, which means more IP will be registered. But again, certainly it's a useful simplification and harmonization is useful for users. And again, critics might say this facilitated multinational corporation at large. That's true. But it also facilitated smaller companies who want to have a bit more of international presence. When some statistic was run here in ASEAN, was interesting to see that the user of the international trademark registration system in the region were basically using the Madrid Protocol to register marks in countries that were very close to the, to the primary country. So it's not that whoever who uses the international registration system register, 150 marks across the world or very scattered across the world. Often is used as a regional tool as well. And that also, particularly for small jurisdiction, might involve SMEs. And so I think, more studies are needed. WIPO does already a very, very good work in tracking, the numbers of, these registration, but also the type of user, the type of filing entities might be a useful study to do. Who uses what, and then what is the geographical distribution of, of this filing, because that is also, I think, something important to understand. So who is the system catering for, and who is the system facilitating? And again, international intellectual property, also the administrative part, is not just run by the international organization, is primarily run by nation, state, and national IP offices. And in fact, also in this third theme of international harmonization of administrative standard, or we need not to forget the regional harmonization of standard, the patent highways that have been created between national offices, the cooperations that go on between national offices in terms of searches for patent and use of these searches to grant national patent, and similar with trademarks and so on. So while the grants remain national, and of course the principle of independence of protection remains crucial. This is a basic principle of the Paris Convention and the international system, that it's, the core of the principle of territoriality, national sovereignty. At the same time, the harmonization of standard and this technical cooperation, it's very useful for the user who wants simplification and, possible acceleration in granting of rights, because that facilitate both SMEs, individual inventors, individuals, and and large corporations. So it's interesting to see how the third, in my view, theme in the international intellectual property development is the administrative, the rise of the administrative international rules, and then the role of the nation state in the harmonization and facilitation of national filings through international or regional harmonization of administrative rules. This is something that I think it's very important to consider. And last, the last theme that I think is emerging, it's really interesting, is from international harmonization of standards to protect. Now we see more and more discussion on international harmonization, or at least international examples of standards to have exception and limitation. And here again, the world is interesting. It goes in waves. I when I look at the developing countries' development and even the developing countries, it's quite a broad brush. We need to have much more detail. India is a developing country, but certainly India is a very, very different developing country than, say, Uganda or, some of the smaller countries in different regions of the world. Some developing countries are a very strong market power, very strong potential technology development, other developing, or, raw materials and natural resources. Other developing countries don't have that, but they still have a large population and potentially can build a very strong knowledge economy. Other developing countries, or even other developed countries, are very small, and they are primarily, transit countries in terms of import export, but they really don't have large internal market, and they might even have small population. And so, the producer, the user of various different rights vary. Some country might be very technology intensive, have very technology intensive industries. Other might have very agriculture intensive industries, and or fashion or design intensive industries. And so national interests also for those countries that want to have high standard, vary. And what we have seen in the past, I would say that's one of the recent, in my view, trend is once the standard to protect have been harmonized, now you start to see more and more countries looking for, well, where are the exception and limitation space? And that's very much driven by developed countries. And the pioneer, in fairness to a lot of these, is the United States of America. And the United Kingdom to a large extent as well. So this idea, for example, of fair use or fair dealing in copyright, it's very much a common law creature, and is something that is now being exported, has been exported to many countries, either through FTAs or through just simple imitation. It has been exported to civil law countries and to, even the European Union. And this is really interesting to see. The use of compulsory licensing, in patent law, or the use of this idea of standardized licensing. So for the so-called standard essential patent, and standardized licensing that has to be fair, reasonable, and non-discriminatory. So this idea of frame terms. These are all legal construct that come from developed country, and they've been exported and are being exported to, in my view at least, to developing country to their benefit. Of course, the idea of compulsory licensing was in the Paris Convention, has been strongly reintroduced in the TRIPS agreement, lots thanks to the push of the Indian negotiators. And from being something in the books, a bit of the nuclear option in the books, the provision has been used largely for pharmaceuticals, and largely by developing countries. But Canada has invoked, the United States, not having it in its book, still has invoked back during the anthrax scare for ciprofloxacin. And so again, the fourth theme in international IP is a search for provision in the flexibility space for all countries to have some exceptional limitation looking at national interest, and how some of these national interests can become regional interests or even international interests. And clearly there is more attention to, yes, IP, but when should IP stop and fair use, or descriptive use start? And this is a discussion that we have been having in every type of intellectual property, in patent, in trademarks, in geographical indications, in copyright, with more and more friction, clearly. But what it's interesting is that this discussion, it's not a north-south discussion. It's really a group of constituencies in every country discussion. It's a discussion that in many ways the businesses that have been developing, the intermediaries economy, the service economy, so the Googles, the eBays, the Facebooks of the world, have brought to mainstream, because they need to use content from others. And so space had to be found for new form of business to work. And so how can we do that? But that has really spilled over in many more interesting conversation. And I would say, the issue, of course, what the many issues that have been brought to the attention of everybody during, the COVID-19 pandemic have clearly highlight many of these issues as well. Access to technology, access to knowledge. Think about all of us home, giving seminars, teaching students online. So, clearly now more than ever, it's crucial to understand how technology and access to technology, it's absolutely necessary for everybody to continue in some way, a reasonably normal life. And then, of course, access to medicine, access to treatment because of the COVID pandemic, vaccine and treatment. And, how that way, though, with the need to develop the treatment and the vaccine, left to the world, without innovation, just because we can copy, we would not have had the vaccine in such a short amount of time. And so, at this point, the vaccine that actually seems to work and seems to work better are clearly the ones that have been developed by patented innovation. That begs the question of access for everybody else. How do we do it? How do we distribute it? How do we make it affordable enough in a way that both promote innovation and, promote some sort of access in a way that is, at least socially acceptable, if not 100% just. I'm a pragmatic person. I'm not an idealist. I think that, idealism is great, but doesn't work in practice. We need to keep our idealistic heart, but then, translating pragmatic solution. And so, social justice is very important, but social justice is, as a social concept, depends. There are many public interests. There is just no one public interest. And so how can we make sure we cater to different constituencies in the best possible efficient way? Also requires technology innovation, and technology innovation does require incentive. We need absolutely to have that very clear as well. And so again, I think, the development of international IP really goes from a small club to a bigger club, to a club that wants to export its protection because the economy is getting larger, and then more actors want to jump and correctly be part of the conversation because the standards affect their economies. And then bigger actor, bigger room, more discussion. So this creation of the so-called country clubs in many ways, and FTAs, the spaghetti bowls, the noodle bowls, depending how we want to define it. And there is this administrative states and intellectual property. And then also these exceptional limitation veneer that has really been interesting to look at. And so now we have a quite varied system that is far more complex than it was. That is more, even if you look at the WIPO services now, a lot is catered for, statistics, WIPO proofs, and things that are becoming more of a service agency rather than just a norm developing agency, which is the transition. The WTO, I have my hope that we will find solution, and we will have again soon a working WTO. It might not be the same type of working WTO, but that's what life is. Life is about change and trying to see what can work the best. I'm also I'm talking to you all in India, which is one of my country of heart. I know India will play a very important role in the future development of intellectual property. Because of the technology, because of the knowledge economy, because of the market sides, because of the people, the population sides. And so we will really be seeing some very interesting shifts and changes, also on the demographics and all that. I see that as an interesting and good development. It's challenging. Some will, some part of the world will put more they will certainly feel more pressure. Um, but that what's development is also about. It's the most important thing is that we could all continue to rise up. The fact that some will develop and they should develop doesn't mean that others should suddenly, there's not just an X amount of development. And so if one develops, the other one underdevelop, we can all go higher. And it's not that there is an X amount of cake to share. There is really a pot that can continue to become bigger and bigger. So here is where I see, the opportunities. And in the discussion and the changing of the economy. And the other perhaps latest development that has been going on already for almost 4 decades, but it's really boom, I would say, in the past 10 years too. It's the role of information technology, not only, and so artificial intelligence, blockchain now, and so on. It's the role of IT in or digital, the role of digital in every single aspect of intellectual property, to a level that now we really have this fusion between the two. And so that has really created this global world in which adjudication, nation state, borders are being put even more under stress, because this is a world that see no boundaries in a world that still wants the boundaries, where nation state wants to have control over over the law and the people and the business. And so that's also, in my view, some of the new trends in international IP. And so, with that, perhaps we can have some questions.
Does anyone have any question? Okay, ma'am, we'll wait for 2-3 minutes if anyone has any question. And meanwhile, I have a question for you. The interesting point that you said regarding the fair use, that many countries have started adopting and giving more importance to fair use in context of IP. Like, how do you think, how far is it related to the principle that is stated in the TRIPS agreement, that only minimum protection should be given to IP so as to facilitate trade, and so that the monopoly that IPR protection gives over the creation is not really encouraged? So how far do you think that countries have started realizing it or giving it importance? How far is the trend that you've observed regarding fair use related to the principle given in the preamble of TRIPS?
So fair use in copyright, or fair dealing in copyright, it's permitted under the 3-step test, first of the Berne Convention, and then the 3-step test from the Berne Convention was important to the TRIPS agreement for all work, not just literary work. And let's remember, I don't see, so fair use is a necessary development of protection. You need, so creativity is based on innovation and building blocks, and by creativity, it's always incremental. So we need to have some space for some uses that might not be authorized. So the idea of fair dealing that was quite restricted, under the UK system, the fair dealing for criticism, news, quotation was not really an open-ended defense or an open-ended right, has been profoundly changed because of the American fair use exception. And the American fair use exception is deeply grounded and rooted in the freedom of speech. So the First Amendment in the U.S. Constitution, in which your right to be protected is no less relevant than right of transformation and so on. And so that goes down to the factor test analysis that has been first developed in US common law and then was introduced in the iteration of the Copyright Act of 1976. We should remember that at that time, the US was not a member of the Berne Convention. And then the US system has been, because it's an open-ended exception, has been found very useful by other countries that have implemented it, a bit domesticating it, with sometimes a fifth factor, only if the work cannot be secure in a reasonable amount of time for a reasonable price. And so again, the question to me, it's not that fair use. So the TRIPS agreement says intellectual property should not become a barrier to legitimate trade. On the other side, this is the enforcement of intellectual property. So the enforcement of intellectual property should be not a barrier to legitimate trade. On the other side, the TRIPS agreement provides for the protection of all type of invention, all type of works, all type of sign without discrimination of the type. And so I wouldn't say that the TRIPS agreement provides for minimum protection. The TRIPS agreement is a minimum standard, so it's a floor, it's not a ceiling for nation state to provide protection. Some countries provide higher protection. Some countries have agreed to higher protection through FTA. And interestingly, though, the TRIPS agreement doesn't impose exceptional limitation. It says country may, if in all right, country shall protect and country may accept, create exception within the framework of the legitimate rights of the owner. While some of these free trade agreements increase the level of protection, but also impose the fair use protection, for example. Now, this goes down to national interest. When the United States imposes in its provision the fair use mandate for the with the negotiated country, does that clearly to promote business that is United States branded, in intermediaries, so Google again and others. But my point to highlight that is that so these provisions have been mandated in FTAs while they're not mandated under the TRIPS agreement. And so you can even see, for those who oppose FTA as maximalist, well, it depends. So my only discussion is always in international IP, like in everything else, you see gridlock in position because people don't want to be reasonable. And people don't want to be reasonable both sides. The minimalists and the maximalists are too greedy and they want either everything too expensive or everything for free. We can't have innovation for free. That's it. We cannot. It's proven we cannot. And we need to find way to figure out how to develop innovation with the correct amount of incentive. Otherwise, company will simply not do it. If we had an ideal world, a nation state that could provide for everything, we would be able not to have IP, but we don't have that. And so it's really needs to go down to public-private partnership operation. And so how we balance these, I think it depends on each individual state for each individual issue and each individual rights. Some rights are less relevant, some products are less relevant, but the assumption that IP it's in the way of trade, I think it's a very dangerous concept. IP is essential for trade. IP is essential for innovation. On the other side, excessive IP becomes a barrier. And the key is to understand what is excessive. And there is no one type of excessive. There is, that's really an assessment that has to be done on a case-by-case basis based on the various circumstances of that specific case.
Okay, thank you so much, ma'am. Thank you so much for answering that. And till now, I think that is all for the session. And does anyone else have any question for ma'am? So I think that would be it for this session today, ma'am. Thank you so much for joining, everyone. Thank you so much, ma'am. I'm sure every attendee over here, whether they are attending this webinar or watching it live on YouTube, they gained a valuable insight on how international law is harmonizing with national laws and what are the trends and the developments that you've seen in international IP. Thank you so much. And thank you everyone for joining. We would be ending this session today. And I'm sure you can connect with ma'am on LinkedIn profile and she'll be happy to answer your questions. And yeah, thank you. Thank you.
Many thanks to you all.
Thank you, everyone. Thank you, ma'am. Thank you.